Hi, thank you for tuning in. Welcome to the It's Your Money and It's Your Estate workshop series brought to you by our nonprofit organization, Financial and Estate Literacy. Our mission is to empower people like you to take control of their finances, their estate, and charitable giving decisions. For the past 25 years, our founder, Peter Coate, and our entire team have been providing these free, unbiased, and accessible 6 weeks programs all over Orange County, California to help you make informed choices that align with your unique needs and values. Now let's start the program. This webinar is the sixth and final session of the It's Your Estate program. The topic is estate administration. Our guest speaker is Richard Huntington. Our moderator is Peter Coate, and this webinar is brought to you by Chapman University. Enjoy the workshop.
I'm going to introduce my colleague, Richard Huntington. We are both California licensed professional fiduciaries, and he's going to be the presenter, and I will be the moderator. But again, we probably have a lot to say about the same topics, so he'll lead, I'll follow. But one thing I wanted to kind of set the table a little bit is before we start is up until now. Remember, this is our last session of the webinar series for fall 2024. Up until now, you've really been thinking about either drafting or amending / restating an estate plan you may have. And so we've talked a lot about the documents. We've talked about beneficiary designation forms for, let's say, IRD assets, income in respect to decedent, like 401ks, IRAs, things like that. And then we've talked about our charitable giving options last week. So a lot of that is the planning. We've been planning. Now, today is going to be more about execution. We're the executioners, Richard and I. No, actually, I mean, it's action time, right? So we're wielding the documents, using the documents. In this case, whether it's an estate administration, you might be doing probating a will, or you might be administering a trust. We're using the documents. So we're going to talk a lot about the fiduciary rules and all that, but also best practices and the probate codes that govern not just professionals like us, but also family members. Now, I want to make sure that you understand too that this is not a scare session. Most of you are going to choose a family member. And so we're not trying to scare you, because we've got a lot of battle stories regarding trust in the estate administration into using a professional, because most of you, it's totally fine and suitable to have a family member serve, but they still have a lot of fiduciary liability and responsibility, even though they're a family member. So we got to understand what that is. So, who you choose is in these fiduciary positions is just as important, really, I think, as your documents themselves, because you can have really lousy documents, but if you have the right fiduciaries wielding the documents, things can be just fine. But then you can also have amazing documents that you've paid thousands of dollars to an attorney for, but if you choose the wrong people to help you, in those fiduciary roles, it can totally go awry and unravel. So who you choose is really important. So that's something you really got to keep in mind throughout this session today. And that's if not only who you're going to choose for your own, let's say, estate plan, but a lot of you may be young enough where your parents are still alive and you're going to be doing this stuff in the future. So you'll also get an idea of what the job is. All right. So, Rich, why don't you come on board here?
Good morning, Trevor. Can you hear me?
I can hear you. Yeah. I can hear you. Do you want to? Are you able to share your screen from your side?
Yeah, I sure am. You want me to get the ask first going?
Yeah, we'll go through that quickly. We've been going through those all week.
Let's see.
All right. So being a being a fiduciary, a lot of people get kind of confused on that because they hear that word all the time. Um, just before we go through this, like, what's the difference between, let's say, a fiduciary like you and I, and let's say someone, another profession like an attorney or some financial advisors or CPA that have, let's call it like a fiduciary standard of care?
Yeah, absolutely. So we're the fiduciary. That's a noun. We are the fiduciary. We hear fiduciary a lot. That's more of an adjective. It's a fiduciary standard or it's a fiduciary process. And that adjective means essentially the same thing, but we are the actual fiduciary. So we are always going to be putting our client's interest before ours. And that's what our vocation is a fiduciary.
Yeah. So we serve in the fiduciary roles that are there in the estate planning documents. Okay, so you got a bachelor's degree. There's a lot of things you got to do to get a license to do this, but you have a good background. You have a CFP. What is a certified financial planner?
It's a credential certified financial planner. You've got to take a series of, I think it's 5 or 6 college courses, and then you sit for a test. Back when I took it, it was a 2-day test. Lots of people breaking pencils during the test. And so once you pass that, then you're considered a certified financial planner. They teach you on the holistic approach of financial planning. So not just investments, but more of a 6 prong. You've got investments, estate planning, risk management, insurance, college planning, retirement. So the full aspects of a person's finance is takes into account. And then to keep your certification, you have continuing education. So I'm always learning more and then keeping that certification.
Awesome. So you're not a lawyer. That's
Nope.
good.
Yep.
Yeah. So I won't call you one and upset you. Um, and you have a fiduciary standard of care, which puts your client's interests ahead of it of your own. Tell us a little bit about, and we'll talk, I'm sure this will come up again in the presentation, but a little bit how you, or just in general, how fiduciaries like ourselves are paid, how we
Yeah,
get.
absolutely. Yeah. So you kind of think of it as we'd like to think of ourselves as a paid family member. We come in and you're going to be paying us directly from your estate. The ways I'm paid is usually it's a percentage of the estate assets. 1% is the number, and then it trickles down if you're over 5 million. And then if you're in the 10 million range, and we could make arrangements to just have a flat rate percentage that makes sense. But anyways, that's paid quarterly from your estate. And the idea is that we're going to be involved with you either at incapacity or at death. And then we're going to be administering the trust estate after death. And that's usually 7, 9 months, maybe sometimes a year, just kind of depending on the complexity. And then we finally get finished and we're off the clock.
Yeah. Okay. So you're so so until you actually are serving in a fiduciary role, though, like let's say you're named in documents or things like that, you don't charge any fees or anything for that, right? If the client is alive and kicking and not
Yeah.
using. Yeah.
Yeah, absolutely. No, there shouldn't be any fees. And if you are working with a fiduciary that is charging, I wouldn't advise it. There's no liability, there's no responsibility just to be named on the document. I
Yeah.
like to contact my clients at least once a year. Hey, how's it going? You still banking at Chase? You still living at the same place? Just let us know that we're still, in the same area and what's going on. But yeah, no, there's never any fees, and we sit down and we talk a lot about services. We talk about the Advanced Healthcare Directive as well, if I'm going to be an agent in that role. But all that's free of charge. There's no fees, and then when we are on the clock, we get paid quite well. So it doesn't, it doesn't really hurt us at all to have a lot of conversations beforehand.
Right. Okay, and then if you're doing a probate or something like that, that's of course statutory fees. We talked about that.
Yes.
You don't have any kickbacks or relationships with any insurance or annuity salesman. Looks like that's a no-no. And
Yes.
yeah, and then we have here your how to get a hold of you. You've signed this, so Richard had filled out the ask first. So this is something you would use to hire an attorney, hire a financial advisor, and even hire a fiduciary that would be. Um, oh, also, like you said, you have a license number 310. It looks like it. Is it possible to look you up online? Like how do you look up a fiduciary?
Yeah, you just Google CA for California and then type out the word fiduciary. If you just Google CA fiduciary, it'll get you to the Bureau's website.
Mhm.
It's under this, let's see, I think it's the State of Consumer Affairs.
Yeah, we're subsumed under the Department of Consumer Affairs.
And yeah, and that's it. So you can search a person's name or their number. They also have an advanced search as well that can specifically search Orange County. And so you can
Yeah,
see all the fiduciaries in Orange County and shop around there as
yeah,
well. I
yeah.
last time I checked, I think like there might be 60 or 70 of us in Orange County. There's not too many when you consider the population.
Yeah, there's a lot of people who get their license but don't necessarily have an active practice. And um, but but again, yeah, so check them out if you're interested. And it's an alternative to a family member or a trust company, a corporation. So thank you for that. And then let's get into our we got a lot of material. Let's get into
Yeah.
our presentation.
All righty. Let's see. Let me find it here. All right, let me go back. Here we go. All right. So today's presentation, like Trevor was saying, is we're not trying to alarm you or scare you, but we want you to be aware of all the duties that are involved to be in this fiduciary position as either the successor trustee or an executor, even serving as power of attorney for finance or as the advanced healthcare directive agents. Um, there's great handouts, not only these slides that we're going through today, but the two other documents, and we're going to touch on one of them today too. Uh, get those printed out, print them out, put them in your file, because there's going to be a time whether you guys as the attendees are going to be in that role for a relative or one of your family members. But print them out and keep them with your estate documents. So no matter who you have as trustee, these are great guidelines, and there's a lot of good information in the three documents as well. So let's get started here. That first thing I wanted to talk about is just get a definition of the terminology. When you're looking at your trust, there's a lot of legalese in there. Sometimes it gets a little bit convoluted on what is what and what to understand. So the first thing is the trust itself, and that's a legal document. You're really that marionette from the grave in a sense. You need to know what you have, and you need to know where it's going to go. And so you get to control where it's going to go, how it's going to go. Is there going to be a time delay before someone gets their money or not? But all that language is going to be in that trust document, and that's what your trustee is going to be looking at so that he can properly administer the trust. We think of the OR words, they end in OR, the trustor, the settlor, or the grantor. That's you guys. You guys are the owner of the trust. You're the one that's making it. Some attorneys use one of those three words, and they use that in the trust document. So remember the OR words. Also, you're the trustee. So not only are you the owner of the trust, that's one hat, but the second hat is you are the acting trustee. You're controlling the trust property. You're holding legal title. So it's like John and Susie, Smith Family Trust dated 2005. It's John and Susie Smith trustees. You guys are the acting trustees. Also, you're wearing a third hat. You're the beneficiary. So you as trustee are deciding what benefit are you getting from the trust. You can have income or principal, you can take vacations, you get, pay bills. You are the beneficiary as the owner of the trust. And that's important to remember, because a lot of times when we think of beneficiaries, we think of the children, and they are actually the remainder beneficiary. So after you guys as the settlor or the grantor pass away, then the remainder beneficiary become what we call the beneficiary. But until then, they're still the remainder beneficiary. And that's where the distribution of the trust assets will go after the passing of the settlors. Another key point to understand is the difference between specific bequest and percentage of beneficiaries. You need to know that your specific bequest has priority over your percentage beneficiaries. So if you have $5,000 to the gardener, a couple of friends, $10,000 here and there, and then maybe a couple large ones at $100,000, those have priority over your percentage beneficiaries. And that's kind of important to remember, is if you have a $2 million estate right now, and you've got specific beneficiaries that add up to 500,000 total, by the time you pass away, who knows what you might have. You might have $600,000 left, and you were thinking your percentage beneficiaries would be getting a lot more inheritance. So it's always easier to keep your specifics very low, just for the little gifts you want to give to certain people. And then it's so much easier for your trustee to administer when it's a percentage when that time comes.
So just to clarify,
Sure.
if you have specific gifts in your district dispositive provisions in your trust, those come off the top. They get paid first, almost like a cost of the administration, and then the remainder, the rest of it, goes to the percentage or the remainder beneficiaries.
Yeah, that's absolutely right, Trevor. And you got me thinking too. It's even the specifics, they don't have the same, I guess you'd say, credentials as your percentage beneficiaries. They're not getting a copy of the trust. It's your percentage beneficiaries that are getting a copy of the trust after you pass away.
Even final accountings,
Exactly.
they don't get
Yeah.
that. So it really is just a specific gift, kind of like and Rich is right. This is not where you put large gifts in. This is more for, those little gifts you want to give as a token of appreciation or something. But
Exactly.
you'd want to right size the gift in the percentage based on your remainder beneficiaries. Okay, go for it.
All right. Oop, another way. Here we go. All right. And the other important thing on terminology is understanding your beneficiary types. It could be family, friends, and charity. Those are your three types. Then you got to decide, is it an outright, a subtrust, or a special needs trust? Normally we see is just outright. So the surviving settler passes away. Now we have our administration process period. 9 months down the road, we're ready to distribute outright to your percentage beneficiaries. Subtrust, that idea is thinking that maybe one of the children, let's say Johnny, has a history of issues, whatever, gambling, drinking, and he can't manage money at all. And so giving Johnny, 25% of the trust assets would be like giving him dynamite. He's going to burn through it right away, and it won't do anyone any good. So the idea is, let's set up a subtrust for Johnny. You're going to have a trustee that's going to be in place after that's established. You're going to get an EIN number from the IRS, and you're going to have annual tax returns, and there'll be an annual accounting. The idea is to put a trustee in place to be that financial parent. Johnny might have a request for a brand new Ferrari because it's pretty neat. And you, as the financial parent, are saying, no, Johnny, let's just get you a Honda Accord and get you from point A to point B. And there's no need for a Ferrari. So you're just that voice of reason, and that trustee decides how to distribute. The same kind of concept is with the special needs trust. But this is to provide for someone that has legitimate special needs, whether it's a physical or a mental issue. and that beneficiary is receiving government benefits. So it could be SSI or SSDI, and the government allows you to have a special needs trust, but you have many rules to follow. So if you are in that realm and you're making plans for a child that has special needs, just remember that there's a lot of extra rules you need to follow, and you can't break them or you jeopardize those government benefits. So it's very important that whoever you have as trustee on that they reach out and find out what those rules are. And the idea is that the special needs trust eventually might run out of money. And when that does happen, you need to have those government protections still in place and those benefits. Anything? Let's see. Okay, and so the other idea.
Let me just go back that slide.
Sure.
So there's two ways to give money out, right? One is an outright beneficiary. So this is there's two ways to get inheritance. One is an outright distribution.
Uh-huh.
And the other is in trust, or in a sub-trust. Now, I'm finding more and more attorneys are using the sub-trust, even if they're not necessarily for, let's say, a spendthrift beneficiary or special needs, or somebody that needs, let's say, an independent third-party trustee. You can even get this distribution where you're your own trustee, but it keeps it separate and identified from, let's say, the danger of commingling it in, let's say, community property or something like that with a spouse. Where an outright distribution, that just comes in the form of a check. And if you deposit that into, let's say, a community property account, you've then commingled, the inheritance with the spouse. And I'm not saying you guys don't like your sons-in-laws and daughters-in-laws, but in California, 3 out of 2 marriages end up in divorce, and it just keeps it separate and identified. And then if they want to bring it over, they can. It's not, can't really control from the grave that way, but it just gives it that little extra spousal protection, little extra, even a little bit of creditor protection, just to kind of keep it away from that individual until that individual wants it.
Yeah, that's a great point, Trevor, because as parents, and we see our children and we see their marriages, you get a sense of it. My daughter just got married last year, and I feel great about it. So not an issue there, but I've had cases with subtrusts where their marriage has split apart. We bought a condo with the funds, and the divorcing husband has no right to it. So and the idea too is, like Trevor mentioned, is that you can make that beneficiary also in charge of their subtrust and keep it separate. But understand, if it's someone else, you're going to be paying them to be the trustee. There's going to be a tax return each year, so there's a little more administrative cost to do it.
I mean, even if they're their own trustee, they're going to be, if they keep that trust, you're right, a separate entity. It's got its own tax ID. It's got to file tax returns, and so there's some administration there. It doesn't just exist without that. Okay.
Yep. Okay. Next one.
Next slide. Yeah.
All right. So getting into the trust documents themselves, we hear a lot about, is it revocable? Is it irrevocable? How do we decide? And so remember, your trust is always revocable while you're living. It's a fluid thing. You can go and make amendments. You could make a restatement. You make changes as you go. One of your beneficiary could pass away and you want to make changes there, or your trustee is no longer available and you want to make changes there. That revocableness is always available to you until you reach either incapacity or death. But remember, incapacity for the estate planning world is it's a pretty high bar to be deemed incapacitated, meaning that it takes more capacity to go buy a car from a car lot than it does to walk into an estate planning attorney's office and make changes. So the estate planning attorney is kind of the judge of your capacity. They're going to interview you, ask you a few questions. But if they think you're fine, then you can make the changes. If they're a little bit concerned, then they might have an independent review, meaning another attorney is going to interview you separate from your attorney to decide that. But the idea is that it's pretty revocable, all throughout. And then once you are incapacitated or at death, then it changes to irrevocable, meaning no more changes. Whatever that trust says at that time, that's what it says. AB trust. We see a lot of AB trusts, and a lot of them were from back in the day, and mostly driven because of the estate exemption was so low. It used to be down at $600,000 for your exemption before estate taxes, then moved up to $1 million. And then over the years, it's been creeping up. And as you know, now it's at 13 million. So with 13 million in portability, you can capture up to 26 million for one spouse passing and the surviving spouse passing later. A lot of people aren't in the $26 million range. And so if you have an AB trust that was designed back in the day because of the estate taxes, then it'd be a good idea to get that looked at. You're just adding more complexity. But the definition there to understand is you're the survivor. That's the A trust, so the above ground. And then the B trust is the first spouse that passes away. So that's the bypass or marital trust, and we call that the below ground, just to help us remember. But when one spouse passes away, then the B trust is established. The B trust becomes irrevocable, and half the assets, half the community assets get split apart, and that funds the B trust. But you might have other reasons for AB trust. You could have a second marriage for each partner, and they've got their own children from the first marriage. And so it's a way of protecting the first person to die assets for their children. And also the survivor's trust, they can go out and change it. So, if they want to change their beneficiaries, it's all revocable on the survivor side. Get remarried, whatever happens, they have control over that. Let's see, administration. An important thing there to remember is the trust assets. It's going to have there's liabilities. We've got beneficiaries. You've always got to protect the assets and be productive, and that's really important. So the idea is that you can't just have a lump sum of money sitting in a checking account and not getting interest. Your assets have to be productive. You can't have one of the children that was living with mom and dad, and now mom and dad are passed away, and that child's still living there rent free. The trustee has to make that real property productive, and charge the brother and sister rent, reasonable rent. And the only one that you get away with is probably vacant lots. You can't really make vacant lots productive, but the idea is that every trust asset you have, it can't be stagnant. And during the process, it needs to be productive. You don't have to be risky, but you just need a little bit of safe income that can be produced. Let's see. So title is very important as well. As you are successor trustee, or even in your role as trustee, you're taking title of that trust asset. So for example, when your successor trustee steps in, on your deed, on your grant deed, they are the person responsible for that real property. It's going to be Smith Family Trust, dated 2005, Johnny Smith, trustee, and that could be, your son. So it's important to understand that the title, not only the responsibility of the trust asset, but even in your trust documents, that you're titling the asset into the trust. So remember, everything is a personal asset until you title it into the trust. So your residence could be Bob and Susie Smith are joint tenants with right of survivorship, or Bob and Susie Smith as community property. That's a personal asset. When you change the title to Smith Family Trust, dated 2005, and Bob and Susie Smith trustees, now you've got a legitimate trust asset. So remember, you got to, once you get your trust documents done, you're not finished. You got to go out and change title of your assets. Same idea
What's that called? What's it called? Changing or putting assets, titling in their trust.
They call that funding. The term the attorneys use, they say you need to fund your trust.
Yeah.
And some attorneys hopefully would hold your hand to get you through that process. But sometimes attorneys are like, here's your trust. We're all signed off. Go fund your trust. And
Yeah.
you really got to be proactive to do that.
So you're saying like you can have your trust documents done. Richard Huntington is the trustee. It says they're right there in black and white. But then we pull the deed on the houses or the real estate or even the brokerage accounts, and it's not funded in the trust. Do you have any authority then as trustee?
Yeah, you do. You got a couple outs there. So hopefully, when you get your trust, there's a thing called a Schedule A, and that's right at the back of your trust. And your attorney prepares that on the knowledge of your assets. So when you're with the attorney, you're saying, "Hey, I've got a brokerage account here at Schwab. I've got real property in Laguna Beach, and I've got a condo up in Big Bear, and I've got an IRA." And so the attorney's going to list these assets on your Schedule A. But remember, an IRA or 401k, you can't fund that into the trust. You can't title an IRA into the trust. But your other property you can, and you're supposed to. But let's say you didn't. You didn't fund the house in Laguna Beach and change the grant deed. So your trustee has the option to go to probate court, and it's called a Hegstat petition. Not really sure how to spell it, but it's like HEGG stat petition. And anyways, what you're saying to the court, you're saying, "Hey, judge, the trustors made this trust. They listed this asset on their Schedule A, but they just never got around to changing the grant deed." And usually the court's going to say, "Yeah, it looks like this asset's supposed to belong in the trust." And then you can get the authority to change it into the trust from a court ruling.
Yeah. Yeah, that sounds like a lot of work.
It does.
So the lesson here is make sure you title it properly.
Yeah, absolutely. Absolutely. All right. All right. Here's my artwork. Got into so now the settler's passed away, right? So that's definitely the triggering event. Your surviving spouse passes away. Now your successor trustee is activated. First thing you do, read the trust and read it again. All the rules and all the powers are all going to be in there. Everything you can do is going to be in there. Can you buy and sell? Can you loan? Can you pay off creditors? Everything, all the rules are going to be in that trust. And so you really want your trustee to understand it. Okay, so now we're in this scenario of the duties. And like Trevor mentioned at the beginning, this is kind of the scary part because it's directly identified in the probate code. The probate code is large. Actually, hold on one second here. If I could hold this up on the camera, that is the probate code. Wow. It's like a phone book, thin paper, hundreds and hundreds of pages. But in section the 1600s, it talks about the duties of a trustee. So it's very important, and the duty of administer the trust according to its terms. So just like I stated, read it and read it again, because all your ways to administer are going to be detailed in that trust. To follow the written directions of the trustor. The loyalty to the beneficiaries. That's an important part too. When your successor trustee is activated and you're alive, meaning you're incapacitated, could have had a stroke, a medical issue, dementia is another one, where your trustee is involved. They're paying the bills, they're paying the caregivers. That trustee is loyal to you and you only. And that loyalty changes when you pass away. So once you pass away, things get transparent. We share a notice of death with all the beneficiaries and the legal heirs that you passed away. They can request a copy of the trust. We have a 120-day notice period where we can't sell a house or we can't do any major things until that 120-day period is over, giving each beneficiary basically an opportunity to object to the trust during that 120-day period. But the idea there is now your trustee is loyal to the beneficiaries. You're saying, "Hey, we've got this account over here at Schwab. We've got the house in Laguna. We've got the condo up in Big Bear. Here's the appraisals for the date of death values for these accounts. And you're sharing all the dollars in and dollars out of that account too, and what the plan is. And so understand your trustee needs to be loyal and fair, and the next one, impartial to multiple beneficiaries. Very important. And that's how you stay out of trouble. I'm sure Trevor and I have many, many stories of where the beneficiaries and their spouses are whispering to each other, and why is it taking so long, and what's going on with the money. So it's important that you communicate and share with the others what's going on.
So if you have a family member trustee,
Yeah.
And he or she is a trustee, but also a beneficiary, because remember, often a son or daughter that's serving as trustee will probably be a beneficiary as well. If they have a rift or some sort of ongoing feud with another beneficiary, does that mean they still have to be impartial
Yes.
as
Yeah,
trustee?
exactly.
Oh,
Yeah. Yeah,
okay.
it's important, and it's a very tough role, and that's important you bring that up, Trevor, because let's say the settler has 4 children, and they put one of the children in charge as trustee. And even though the one they put in charge has had history of fighting with the other sibling and not getting along, you got to be impartial during this time period. You could get back to your fighting and not getting along after this administration is over, but during the administration, you can't play favorites. You have to give everyone the same scoop as you go along. Very
So if you,
important.
so if you wear that trustee hat, you're governed by these probate codes, irregardless of your relationships
Yeah.
with everyone else. So just a word of warning as you guys choose trustees, keep that in mind, because I can almost promise you that people don't amend their relationships when you die. In fact, if anything, you have been keeping it civil, and people have been tolerating their grievances in your presence while you're alive. And then when you pass away, you're no longer there as that common ground, and often people spin off into their own camps. So if your kids don't get along, you may consider, another option just to kind of keep the peace, and keep this stuff out of court, or out of just, issues, because it's very difficult to be impartial just with someone you don't like. Um, and
Yeah.
even for Richard and I, when we're administering trusts, it's, obviously if you have 4 beneficiaries, you're going to have just human nature. You'll have one that you're kind of a favorite, and then you have one that's not the favorite, but you still got to deal with them all the same. So, that's just how it goes, and it can be difficult. Okay, what do you mean by self-dealing? If I'm a trustee, how can I self-deal? Sounds kind of cool.
Yeah, it does sound cool, but you're not supposed to do it. So the idea there is we've got a condo up in Big Bear that we need to sell, and the neighbor reaches out to you and says, "Hey, I really want to get that condo. I'll give you an all cash offer for $400,000, and you don't have to list it. You don't have to pay commissions. We'll just make a deal." And that's an example of self-dealing. You can't do a handshake deal, especially on real estate. Real estate has to go out on the MLS, so that the whole nation can bid it, and you're going to get the best price. You're going to get the market price. So selling it to the neighbor for 400 grand, you don't know if, was it really worth 500 grand? You have no idea until you get it out there on the market and see what the market demands.
Yeah.
So it's, and the idea is it's not fair to the other beneficiaries for the one trustee to be making that decision. This is how we're going to sell it.
Yeah.
Yeah.
I was
So
thinking, I was thinking other things like, a lot of people have uh, beneficiaries, children that they may choose as trustee that are also real estate agents.
oh yeah.
So,
Yeah.
so are you going to, and all trustees are entitled to fair and reasonable compensation. So are you going to pay yourself a commission on top of your fair and reasonable uh, compensation? or are you going to farm that out to another broker, for example? Also, I've seen problems where the trustee is a contract and they hire themselves to, let's say, fix up the kitchen or get the house ready for sale, and they invoice themselves, a lot of money, extra money. But they're their own trustee, so they can approve it. And this is an example of self-dealing. Also, loaning money to the trust as trustee. So, setting your own interest rate, getting that, that's a no-no. You can't really do that either. So you can always reimburse yourself. That's not a problem. But actually, like giving the trust a loan because there's liquidity issues and then establishing an interest rate that's, obviously too high, things like that can be a breach of that no self-dealing code.
Yeah, yeah, absolutely. When they're in that role of trusteeship, you've got to have higher standards, like we talked about, a fiduciary standard, no kickbacks, no payoffs, nothing
Okay.
that's not normal.
Okay, before we get on to the next list of, because these are really important, you guys, and I know the probate code is going to be boring and they'll put you to sleep. And if you have insomnia, you can read the probate code that Richard has. But I just want to get too far ahead with the questions. So one of the persons said, if you list specific property bequests, but that item no longer belongs to you, can you state in the trust? Well, if you no longer have that particular piece of property, if it says it's in your trust, but the deed doesn't say it's in your trust, then it's not in your trust. Meaning if you've already sold it or whatever, it does help if you update your trust to reflect that, but it's not going to be a problem if you don't. Another question is on property appraisals at death, who can do them? Real estate agent, property appraisal. Rich and I usually get a certified property appraiser. I mean, some people you could use a broker's opinion letter, things like that. But usually we're dealing with hundreds of thousands, if not millions of dollars in assets, and to pay a certified appraiser $450 to get a correct appraisal amount that you can use for your step up in cost basis of all these assets is, I think, important. So and it can also be used as a basis for fees and things like that. So, but you need something. You need something in case you get audited that you've used. If you have nothing there and you get audited, the IRS could say, well, what did you use to value this? So you need that in the file. And then
Yeah,
the last,
go ahead.
Okay,
I was going to say that's a great point, Trevor, because a lot of us do have real estate, and that step up in basis is immense. I mean, you bought your property for 200K back in the day, now it's worth 1.5 million. You pay that $400 for that official appraisal, and it is wonderful for your children or your beneficiaries because they could sell it if they want, and they have low capital gains because they've established an official appraisal and date of death. They can rent it out and collect rental income and start depreciating the asset as well if they would like. And that gives you that established depreciation base as well. So there's a lot of great benefits, not only in the step up in basis, but a great benefit of getting an official appraisal. So try not to, I mean, there is a shortcut. You could have a realtor do it. That could work fine. But you don't want to have to explain yourself to the IRS if it's not official.
Yeah. And the problem with real estate agents doing brokers' opinion letters is they kind of are, I don't think they're as impartial as a certified appraisal because they're often trying to get the listing or they're, doing so they may elevate that value a little more to get you excited. So better to just do a certified appraiser. And then the last thing before we go on, trustee is not the same thing as an executor, correct? And that is correct. An executor is someone that you nominate in your will who will, if it all goes well, will serve as your executor during the probate of your probate estate through your will. A trustee is the trustee of your trust. Different fiduciary positions, different documents. And if you have a trust and everything is titled properly and you don't have any issues with that, you'll have a pour over will. You'll still have an executor nominated, but chances are you won't even use that will. It'll just be like an emergency document that will lodge with the court and it'll just stay there forever, but you will never actually open a probate for you.
Yeah, that's a good point.
Okay.
All right. So the other probate codes, they're there to read, to understand. I think that the first one, to make the assets productive, we talked about that. Keep your trust property separate and identified. So you need to know what is a trust property. You got to find all the trust property out there. Any claims, you have to enforce any defense against the trust. If a creditor comes at you, or if one of the beneficiaries, want to say the trust is invalid, your trustee has to defend it. I think the most important one is that bottom one, where we see a lot of issues happening if you don't do it. And that is, make sure your trustee communicates to the other beneficiaries. Not only keep, a group email, hey, here's what I'm doing this month, here's what happened, but they have to account as well. And so at least after 1 year of the trust administration, you have to provide an accounting to all the beneficiaries of every dollar in and dollar out since the date of death of the surviving spouse. And that's really the biggest one. Everyone wants to know, and it's your job. You need to be transparent about this, and show them the accounts, show them the balances of the accounts, and every money in and money out. Really important one.
That is the most breached duty I see from, let's say, family member trustees, even professionals, to be honest, that they do not account or provide accountings. There's no transparency. They're not communicating information to the others, and everyone wants to know what's going on. That is definitely a ticket to trust litigation if that is something that is sustained and it's not rectified. So, you got to be able to. I'm not saying you have to be a CPA or do an accounting, but you have to at least keep the books and then make sure that you're organized enough so you can, let's say, hire someone to provide an accounting for the rest of I said family, but the rest of the beneficiaries.
Yeah, that's a good point too, and it makes me think also understanding the psychology of an inheritance. If any of us out there, if you've had received an inheritance, it has a different psychology for those dollars. Trevor and I are out working. We make a wage. We decide how to spend our money. If we've got extra, we could take a vacation. But when it comes to inheritance, it's almost like winning the lottery. It has a different psychology about it. All those dreams that you couldn't afford, now you can afford. So there's a different, anxiety about the money as well. So remember that, it's important to keep everyone informed, keep them transparent, and reasonable, reasonable expectations. It's going to take 9 months before you get your money. It's going to take 10 months before you get your money. You just let them know.
Communicate.
Yeah, exactly. All right. So another one of my fantastic drawings here. So now the truster has passed away. Like we talked about before, you got to step into action. So I'm gonna let's see. I'm gonna stop sharing this screen here for a minute. If I get my, oops, not sure how. There we go. And then I'm gonna share. So this is that handout of one of your handouts that you have, and it's the one titled "Being an Executor." And that's the one, these are one of the three that I want you to print out and put in with your documents and just keep them in there. But if you scroll down on this one, I'll scroll down to section 3 here. These are the things to do when a person dies. It's your checklist. It's a wonderful checklist. It was developed by Peter back in the day. And it just gets it going. So whoever your trustee is, have them look over this list. Right away, there's an emotional impact. The matriarch has just passed away. Is there a surviving spouse, or has a surviving spouse passed away? How are the children handling it? Do we need to arrange any support? Is there any special needs children that need support? Dependents, care for pets, that's a big one. Cleaning the refrigerator, changing the post office address. Your trustee needs to start getting the mail so they know what to pay for. Just all kinds of things. You're prepared to arrange for the obituary. That's another thing too, is sometimes when the surviving spouse passes away, your trustee doesn't have any access to money until they get that death certificate. So they might not be on your account yet as trustee. So they're going to need to front the money for funeral arrangements, burial or cemetery. So your trustee, and Trevor and I often are in that situation where we're waiting for 2 weeks to get our death certificate, but we need to pay out some money to get things done. So have your trustee keep those receipts, and then eventually they'll get reimbursed when the time comes. You got to notify your family and friends. You're going to notify if there was a power of attorney for finance, and let them know their job is over now because their agency for their principal has passed away. Safe deposit boxes. Find out, is there any safe deposit boxes? You want your trustee to know that if you have one. And then also don't keep your wills or your trust documents in your safe deposit box. That's another important one. Let's see. And find out if there's any IRA accounts or retirement accounts. What about businesses? Has there been a business or a partnership arrangement? So your trustee's got to identify the assets and find all these assets. So the more organized you are, keeping your account statements together. A lot of people aren't even getting account statements anymore. They're just doing it online. So you want your trustee to know your passwords and what you're doing online. Death certificates. How many death certificates do you usually get, Trevor, when on the average?
I don't get that many.
Yeah.
I usually get about 3 to 5.
Okay. Yeah. Consider
I
that
mean, yeah. You need
each.
one. Yeah, you need them for every real property. You need one for the
Mhm.
affidavit of death of trustee. You need to bring in, like, usually now, at least I don't know what your experience is, but if you're actually going into a financial institution like a retail bank or brokerage, you can bring an original, but they'll make a copy, give it back to you. But then there's other if there's pension like CalSTRS or those sort of things, you're going to need one for them. So it kind of depends on what they have and what you need them for.
Yeah,
But
exactly.
yeah.
Yeah. Each financial institution is going to want a live, I mean, not live, but an original copy. And usually they'll mail it back. A lot of times I'll just give them a return envelope so they can mail me back the original as well. 30 is a big one. Deal with fire, theft, liability, and auto insurance. Your trustee's got to make sure that the home insurance policy is in place. Very important for fire and earthquake. Even if they are underinsured, your role as trustee is to be overinsured. Make sure you have insurance on everything.
So
Yeah.
so regarding that, if you take on a fiduciary position, trustee or executor or even agent for power of attorney, um, are you personally liable for any losses that may happen to the trust property?
Yeah. Yeah.
Yeah, you sure
Yeah.
are.
Yeah.
And
Absolutely.
and so that's one of the things that's so important regarding insurance because things change when you die. Meaning, your auto insurance may or may not be valid on that vehicle that was the decedent's, and those tend to drive off if you don't secure them. Other family members or something taking them home or using them. Um, the and then fire and liability. So one of the things is vacant homes. Okay, often someone dies and it may take, you don't sell that house 2 weeks later. It may take months to get that, get the personal property sorted out, getting it ready to sell. Most of your insurance policies that you have right now have a vacant clause in them. And you need to know what that is so you can tell your trustee, or your trustee may need to know that at least most of them I see have about, I think it's 2 or 3 months where it can stay vacant, where the insurance company will still honor the claim if it burns down, for example. But if it's been sitting there for 6 months and it burns down, and you haven't, let's say, got a new policy like a vacant, you can purchase vacant house policies, which are more expensive, which also gives people pause because they always think they're saving the estate money if they don't pay for expensive things. However, you're really exposing yourself as trustee by not insuring that property properly, because that they may not honor that claim if it burns down after 6 months after being vacant. So very important to kind of understand the insurance situation of the decedent.
Yeah, so true. And also your trustee can be you want them to be an added insured on the policy as well. That will help give them some protection there too. But I think a good example is some of us might not get earthquake insurance, because we don't feel it's necessary. But when you're in the role of trustee, it's different. You've got to take all insurance that's available because of the what ifs. Let's see. So lower on the list, I think the big one is 37. Not all valuables look valuable. We all see the what's that one show? The Antique Roadshow, and we're surprised that this little artwork that was bought for $2.50 at a thrift store is really worth $5,000. And so we're not experts on valuables, and so your trustee needs to be bringing in someone that is, or more familiar. So a lot of time, Trevor and I will use estate sale people that are very familiar with all the different knickknacks that are in the house. If it is gold or coins, we can bring that to the jeweler for gold, and the coins we can bring to a coin person, and that has a lot of knowledge there, and so we could get values. You want to value things. All the other items would be at a garage sale value. How much would I get if I brought my couch out to the driveway and I put a for sale sign on it? Even though it cost me $500 to buy the couch, it might, you'd be lucky to get $50 for it, because it's a hassle. Someone's got to haul it away. So think of it that way. But a lot of time, Trevor and I will have family days. And so after the elder has passed away, hey, all the family members, you guys come on in and pick out what you want. But we do have to keep it kind of even. So if one person's getting the diamond ring, we need to put a value to that and say that's worth $2,000. And so that we kind of, could keep it fair as possible.
Yeah.
But
and you guys can be proactive in helping your trustee with that stuff. So in the back of your trust, you have what's called an assignment of personal property. It's the only place in your trust where there's two columns. One says the item, the other says beneficiary, and you can put them all the stuff that's important. Jewelry, art, maybe family photos, sentimental stuff, and you can name the beneficiary that you would want to have it. That is extremely helpful for a trustee to have. And I'd say 9 out of 10 of these things aren't even built. They're just empty.
Yeah.
But those ones that are very helpful because it gives us guidance and it helps us secure. It helps us. Okay. There's an engagement ring. I need to find that and secure it, and to make sure it goes to so and so. So it's like, and you can cross out their names and add names and do everything right in the margins. It's not like the regular parts of your trust where you're not supposed to do that. And so it just kind of keeps things going. But again, it takes some thought, it takes some time, and but it's very important to kind of keep that going.
Yeah, no, it's so true, Trevor. It avoids a lot of conflict, and it just makes it run smoother. And it lets your trustees say, "Hey, mom and dad wanted it this way. This is who gets this." So, if Johnny took the painting off the wall before we got in there, and it's supposed to go to Susie, then everyone gangs up on Johnny. Hey, Johnny, you got to bring that back. Mom and dad want it to go to Susie. So that's really important. Okay. Administrative process. So, like we talked about earlier, there's a triggering event. Your successor trustee and even your agents for your advanced healthcare directive and for your power of attorney for finance, they're not into effect until you've been deemed incapacitated. And usually there's going to be language on your power of attorney and your advanced healthcare directive. What is incapacity? What's that mean? And so usually it's one doctor's note. And you want to get, your primary care doctor that knows you the best to kind of deem you incapacitated. Some people might use two doctor's notes, but we really don't like that. It's very difficult to even get one doctor's note when the time's right. But having two, that usually means a doctor that doesn't even know you to deem you incapacitated. And then the other triggering event is death. And so when that happens, that's when your successor trustee takes control over the trustor and or the trustee, and you are you're now in charge. So you're deciding what bills to pay the utilities, pay the insurance premiums, pay the caregiver. Are we going to pay $5,000 to the Jamaican lottery scam? No, we're not going to do that. So you're coming in, you're wearing that hat as successor trustee and making the prudent judgment on what gets paid and not paid. Again, we talk about reading the trust and read it again. There's a lot of language and rules and powers and directions, and all that's inside the trust. So you really want your trustee to take control of that and understand it. And if he needs to go talk to an attorney, that's a fantastic idea. Trevor and I are always represented by attorneys throughout the process, but we're not utilizing them as much as we did when we first got started. But for the average person, if it's a son or daughter as trustee, you want them to go talk to an estate planning attorney and have that attorney hold their hand throughout the process to make sure they're following the rules. They're going to be paying them at their hourly rate, but it's invaluable to make sure you're getting the job done right. So successor trustee, remember, is not the owner. They're not the settlor, but they're assuming the responsibility as if that asset was theirs. So your successor trustee is going to be on that grant deed during the administration process. And when that property gets sold, they're the responsible party for that asset. So that's important. Again, the trust is going to outline all the duties, authorities, how the distributions are going to go, powers and provisions. So you as the settlor, you're kind of that marionette that controls the strings even after death. So you decide where your bounty is going to go. And then we've already talked about special needs trusts, subs, and AB trusts. All right, another fantastic artwork. So now your trustee has to identify the assets. Is there a boat? Is there a car? Is that painting up on the wall valuable? Is the house titled in the trust? You got to investigate and find all these different assets. Let's see. Here we got, this is interesting. So on the subtrust idea, and also with AB trusts, they have what's called a HEM standard. And what that does is it gives your trustee discretion on the HEM standard. And it's kind of a well-known acronym that they use that means health, education, maintenance, and support. And it offers a very broad discretion for distribution by your trustee. So what I mean is that, you might have a trustee for the B trust and you have a surviving spouse who's in charge of their A trust, and they could have HEM's discretion into the B trust. The idea is that the survivor trust should get used first, but sometimes not necessarily. It could be, real property and they're out of liquidity and they need to start using the B trust to take care of themselves. And so that you're protected by these distributions if it follows the idea that it's for health, education, maintenance, and support. And that pretty much means almost anything. The other duty that your trustees got to do is what we call marshaling the accounts. That is the trustee going into Chase Bank and providing their ID, providing the trust document, providing the death certificate, and saying, "Hey, I'm the successor trustee," or if it's incapacity, be providing the doctor's note. So you need to get your name on the accounts as trustee. Remember, there's no commingling. You gotta keep this stuff separate. The trust accounts and bank accounts have to be separate from your personal stuff. The other big one is that change of address. And it's pretty easy to do. It's a little more complicated actually now, but you go to the website, the USPS post office website, and you can start the process of changing the address. And sometimes now they require you to start that process there, and then you have to go into the branch and ID yourself. But you want to start accumulating that mail so you know what
So when you say change the address, you mean forward the address to the trustee's address.
Correct. Yeah. Yeah. Both actually. You're gonna forward the address as your first step. And then once you start getting those documents, then you're calling up like SDG&E and saying it's still the same service address. I just need you to change the billing address so that you start receiving the mail. Because there's going to be a period where that forwarding address stops, and so you want to make sure it's a two-step process, not just forwarding, but then changing the Charles Schwab statements and making sure those are going to go to your address. Same thing with the marshaling. We talked about financial accounts. You're doing the same thing with utilities, the taxing authority, the insurance company. So you really, you're stepping into the shoes of that trustor, and you have to have access to pay all these things, to pay the premiums, to pay the utilities, and so on. Oh, this is good too. So normally, when you're the settlor and you have a revocable trust, everything's going to flow into your 1040. But once it's irrevocable or you passed away, then we have to get an EIN number. So your successor trustee gets an EIN number that kind of starts a different vehicle. And now you're going to be doing a 1041 tax return, and you're going to be paying at the trust tax levels. There's ways to kind of avoid that. It's called a K1, Form K1. If you have too much income inside of the 1041, you can distribute through a K1 to the beneficiaries and have them pay at their tax rate on their 1040. And then also you want your trustee to feel comfortable with hiring professionals. So your trustee's in the middle there on this drawing, and then you've got your CPA on the left and your financial advisor on your right, and you might have an insurance agent. But make sure your trustee is comfortable in a business sense to reach out to all these professionals, to have the conversation with them as well during the administration. Let's see. So on the administration process, again, you got to have your trust records. It's important. You name all the assets in the trust. You got to know what your cost basis is and your step up in cost basis. So you need to get all the data death values like we talked about earlier, getting that official appraisal done. When it comes to brokerage accounts, it's pretty easy to get that data death valuation because the market closes on that day and we'll know what the value is. But your trustee has to let the advisor know, the settlers passed away and you need to get me data death valuations for this certain date. You need to select a good accountant. So a lot of accountants and CPAs are comfortable with 1040s. That's our personal tax return. A 1041 is a different animal. So you want to interview that CPA and make sure they're comfortable with completing the 1041 tax returns. And then your role as trustee is providing the accounting and reporting to the CPA so that they're able to, put in all the medical exemptions you might have or the professional fees that you might have that's going to lower your tax liability. Right away, Trevor and I are making lists of those assets. We're making sure we've got the proper insurance policies and that cost basis again. Sometimes you have to understand the distribution of income and principal because it might be delineated in the trust. And so you need to identify that separation as well. And then, the bottom one, we've talked before about the distribution of trust assets to a subtrust. The idea here too is on a subtrust and an S&T, special needs trust, your main trust creates these subtrusts. So the main trust then says Johnny's going to have a subtrust, and now you've got two different vehicles. You could still have the main trust going on, but now we've got a new vehicle with a subtrust, and it's going to have its own EIN number, its own trust administration, but it gets funded, from your main trust for, let's say, 25%, and 25% of those proceeds. Now that subtrust is up and running, and it's its own, its own vehicle that needs to be administered. This is just another drawing on AB trust. So kind of the best one.
Rich, we only got about 5 minutes, so I don't know if you want to.
Yeah, that's a good point, Trevor. Let's get to this last one here then. So we see issues. We often, even us as professionals, sometimes we have two bad decisions to make, and we got to go to our attorney and find out what's the best bad decision. So it's important to understand that the more guidance you can give your trustee, the more definition you can give them, the better you're making their job. And the two here's several of the major issues that we kind of discuss is that commingling of the trust funds. You want your trustee, they have to go out and set up a separate administrative account for the trust so that monies can go in and out, pay bills from there. You might have a little reimbursement period like we talked about where we don't have a death certificate for 2 weeks, but it's appropriate to use your own money, but get reimbursed and save those receipts. But everything's going to get accounted for, and it makes it, it's the proper way and makes it much easier is to have that separate account that you're going to account for. You do not sell real estate without an MLS offering. No handshake deals. That real property needs to be out on the national market, so you're getting the best bid for it. So we want to make sure your trustee isn't, selling it to their friend or something like that. And then also, remind your trustee that they're the quarterback here. You're going to be in charge of everything, and feel free. You have the capacity to hire people, and that's very important. So you're hiring agents to take care of sections for you. So if your trustee is not, obviously you'd like to have them business minded or have a kind of a concept of it, but maybe they might not be. So hire a bookkeeper that's going to help you manage that account that you're using to pay bills. You're going to hire financial managers. You might need a property manager. So mom and dad maybe took care of the rental property, and now you're not going to have the time to take care of that rental property. So you're going to hire a property manager to do so. There might be a family business. So remind your trustee they don't need to take on all these tasks and micromanage everything. They have the ability to hire people to help support them. And the big one that Trevor and I talked about earlier is that we see all the time is communicate with the beneficiaries. Include them on what's going on, what the decisions you're making, what the plans are. Realistic timelines is really important. So remember, nothing can be done in that first 4 months. Nothing major can be done. And then after that, tell them it might be, month 8 or month 9 before we get to that point of distribution. What about fees? I tell, if it's a lay person, a family member, they should charge. We hear sometimes the family member doesn't want to charge because it's taken away from everyone's inheritance. But I think, at least 0.5% or 1% is a good idea for a trustee. We're seeing corporate trustees are getting into the 2% and even higher range as well. But it's not an easy job for a person that's never done it before.
Yeah, you can do it. You can do a percentage, or you can do an hourly. But again, being organized, documenting your what you've done, your tasks you've done, so you can basically justify what your compensation would be. That sort of it's very good to be, to anticipate people questioning fees and things. So you have a good background or a good backup as to why you would charge what you did.
Yeah.
Now there's a question too, or comment. It says, sounds like on real estate, The successor trustee would need to change title of deed. In other words, record a new deed with change of trustee. No, that you're kind of on the right track, but what happens actually is we record what's called an affidavit of death of trustee. Now, this may be if you're a spouse and your spouse dies and you were co-trustees, you record this, your spouse died. Or when the surviving spouse, or if you're single and you die, your successor trustee records a affidavit of death of trustee. Now, all it does is change the trustee of the trust on that deed, or at least it accompanies the deed, but it's still titled in your trust. So you don't need to change title, in other words. Yeah. Title will not change until you actually sell the real estate to another party, and then you'll record a new grant deed. But that affidavit of death of trustee, which informs the Orange County recorder and others that there's been a death of the original trustee and now there's a new trustee, gives that new trustee authority to transact and all that. If you don't do that, there's a lot of things that get delayed, like supplemental property taxes. If you're trying to sell the property, you're going to have to record it anyways in escrow. So you might as well get that done right at the beginning. Okay. All right, Rich, man, you powered through that. And we got to do it all again at 1 o'clock at the Susie Q Center in Laguna Beach. So you guys are welcome to join us there too. Okay. Fouad?
Right before we tackle possibly the last questions that we may have for the purpose of the video, thank you all for being with us. Again, as I stated at the beginning of the workshop, please stay with us till the end, until we actually end the webinar. You'll have a survey that pops up. This is the last session, and we can only improve the program with your feedback. So if you could stay with us until we end it, you'll have a survey pop up, and we value your feedback. So thank you again. See you guys in the next series, Spring 2025. And thank you for being with us.